Hello, and welcome to the Fort Jackson Legal Assistance Office. I am Captain Reyes, and today we're going to talk about divorce in South Carolina, especially how it pertains to military personnel. Divorce issues are complex, so do not rely exclusively on the information presented in this video. If you have more specific questions or need further information, you may request an appointment with the legal assistance attorney. The first thing to understand when talking about divorce is that there is no military divorce or any military family court. All divorce proceedings are carried out in the family courts of the state in which you file for divorce. Please be aware that the attorneys in this office will not be able to represent you in court. This means that unless you proceed pro se or without an attorney, you will need to retain a civilian divorce attorney. Second, the plaintiff or the person seeking a divorce must have resided in South Carolina for at least 1 year to be able to file in South Carolina Family Court. Until the plaintiff's residency is satisfied, you will not be able to file for divorce in South Carolina. If the service member has not resided in South Carolina for 1 year, the divorce must be sought in the same state of the marriage. Of the 5 grounds for divorce in South Carolina, there are 4 fault-based grounds. They are adultery, physical cruelty, which can be considered domestic battery or abuse, desertion, which requires a year of absence by the defendant's spouse, and habitual drunkenness. To pursue a divorce based on any of these grounds will require showing of proof that will need to satisfy the legal definition under the state of South Carolina. This can be shown through testimony, letters, private investigators, photograph, or more of the same. A South Carolina divorce attorney can best identify which grounds for divorce you may qualify for based on your specific facts. Additionally, there is the no-fault divorce. The last ground for divorce and the most utilized ground is the no-fault divorce, otherwise known as living separate and apart. This requires the parties to be living in separate homes for at least 1 year. This means the parties cannot live together for the continuous time within that 1 year. It also means that any reconciliation, brief cohabitations, or having intimate relations within that 1 year period may reset the timeline for living separately. This living separate and apart will need to be shown by evidence such as personal statements, witness testimony, mail from different addresses, and any other documents that may tend to prove the separate living accommodations. Of particular importance to service members, however, is the regulation which governs a requirement to provide temporary spousal support to a spouse. Each service has a specific regulation governing the spousal support, but we will focus on the Army's AR 60899. Under AR 60899, there are certain situations which may arise during a marriage and its dissolution where a soldier can be required to provide support to their spouse in an amount governed by regulation. Considering that a no-fault divorce requires a 1 year continuous period of living separate and apart, the temporary spousal support requirements of AR 60899 may trigger if you and your spouse decide to live separately. If you believe the requirement applies to your situation or have questions about it, please make an appointment with us. Once a divorce complaint is filed with the family court and it is served on the defendant, the length of time before a final divorce decree is entered depends on the grounds for the divorce and the backlog of cases. For the grounds of desertion and separation for 1 year, there is no mandatory waiting period before a hearing may be set. For the other fault-based grounds, a final hearing may not be held until 2 months have passed since the filing of the complaint. A separation agreement is an agreement between the parties recognized by the family court, where the parties can come to a temporary agreement pending a divorce on issues of child support and custody, spousal support, and other various matters of concern. A separation agreement, however, is not a divorce. A divorce is final only when a final divorce decree is entered by the court. Separation agreements are an area in which it is very beneficial to have a divorce attorney negotiate the terms of the agreement. Once the agreement is entered into the family court, it can be recognized and enforced. The Fort Jackson Office of the Staff Judge Advocate does not provide separation agreements. Lastly, when pursuing a divorce, military retired pay is an issue that is often overlooked. In South Carolina, military retired pay is considered to be part of the marital estate and thus is subject to division by the court. There is no minimum length of time the parties must be married before the retired pay is subject to division. However, new rules have been enacted by the 2017 National Defense Authorization Act, which caps the amount of retired pay that a spouse can claim based on the service member's rank and years in service at the time of the divorce instead of the rank and years in which he or she actually retires. The information is intended to provide some of the basic questions you may have about divorce under South Carolina law. If you have any questions specific to your case or would like to make an appointment for assistance, please contact the Fort Jackson Legal Assistance Office at 803-751-4287. Thank you.